Namaste. Good morning. This is 44th episode of AAA webinar series. Today we are actually discussing on the subject of SARFAESI. Various judgments has been given by Honorable Supreme Court in the year 2022-23 till now, till January. So we have analyzed these judgments, and we have seen that every time ahead, every kind of time as passes, all the hurdles are being cured from the SARFAESI law. The implementation is absolutely fine. The lenders are getting better results out of SARFAESI. All kind of excuses, all kind of efforts to save the property, mortgaged property, has somehow been challenged, and the Supreme Court has finally held that it is the right of the lenders, these secured creditors, to recover money out of the secured asset. See, we deal with insolvency law as well as SARFAESI law, RDB Act, and we have seen that the SARFAESI law is presently much cleaner, much faster, and effective as compared to insolvency and bankruptcy code. See, why I'm saying so? Because see, the section 26 capital E was inserted in 2016 in the SARFAESI Act, where there was no other. In case the security interest is registered with CIRP, the central registry, then this security interest is supreme, and even the tax authorities or any other kind of statutory dues would not have any right on that property. So this has been very clear, and since this 2022, we have seen that the people were kind of efforts that was being made by the borrowers to circumvent the possession and to circumvent the sale of the secured assets. For example, they would say that the secured asset was an agricultural land, and even if it was a farmhouse or even if it was a industrial building now, but they were saying that it was basically still registered with the Tahsildar or Patwari, so it's an agricultural land as per the records of the Tahsildar. So that has been resolved in this year by the Honorable Supreme Court. Also, in various cases, this tenancy was also being created to circumvent the possession by the secured creditors. That has also somehow been settled by the Supreme Court, that the tenancy rights, whatever it is, that has not to be dealt by the DM or any other authority. It will have to be dealt by the TRT, because there was an amendment made in section 17, and that was also related to any tenancy. The jurisdiction was shifted to TRT, the tribunal. So it was not with the Rent Control Act or any other civil court. Now this is shifted to DRT. Similarly, the MSME dues, some people said that because of the MSME facilitation committee that has passed an order and lien on the property, so that would have a right on the property before the secured creditor. So that has also been said by the Honorable Supreme Court that will not happen. So these appointments of advocates, the capacity of the DM, capacity of CMM, all that has been properly adjudicated by Honorable Supreme Courts. And today we are in fact discussing all these judgments where these cases are settled and the SARFAESI law has been made as a kind of effective, speedier, and cleaner law as compared to the other recovery modes by the secured creditors. I will share my screen and we'll go forward. So thank you participants for joining, and we are in fact after the preamble which has been given to by me, we now move on to the judgments passed by Honorable Supreme Court of India in the year 2022 or in the month of January 23. So this case Sridhar versus Construction Private Limited, this was the judgment delivered on 5th of January 2023 by Justice Mukesh Kumar Rishik Bai Shah and Justice M.M. Sandesh. And this judgment was related to the agricultural land. In this case, the DRT, in fact, dismissed the securitization application by the borrower, observing that the land in question were not exempted from the provisions of SARFAESI Act. The DRT land is not somehow a SARFAESI agriculture land, so it is not exempted, because Section 31, subsection 1 of the SARFAESI Act actually says that the agricultural land cannot be put to auction. Agricultural lands are not covered under SARFAESI law. So therefore, the borrowers, in fact, did not file any evidence to prove that the agricultural activities was going on. The land was mortgaged to the secured creditor. So this was the observations of tribunal. So then this High Court of Telangana in writ petition. So writ petition was filed and observed that in view of Section 31, subsection 1 of the SARFAESI Act, the property being an agricultural land could not have been put to auction, as there was a violation of Rule 8, Sub-Rule 1 and 2, and Rule 9, Sub-Rule 2 of the Security Interest Enforcement Rules. The High Court allowed the writ petition preferred by the borrowers, quashing and setting aside the order passed by the DRT, as well as the possession notice and the sale notice by the Indian Bank, which is a secured creditor, and also the scale of the property mentioned in the sale notice pursuant to the auction held. So this was the issue with before the Honorable Supreme Court, whether it is agricultural land. And finally, it was held by the Honorable Supreme Court. Yes, the burden lies on the borrower to prove that the property is an agricultural land. Now, the Supreme Court says in this case, in fact, two things Supreme Court has said very clearly. As you probably would be knowing that whenever SARFAESI action was being taken on any of the borrower, they were rushing to high courts under Article 226, 227, as the appeal before DRT would require at least 50% of the debt as advance payment to the appellate tribunal. So this was the condition. So therefore, in fact, most borrowers would go to high courts under Article 226 and 227. So this is one such Supreme Court judgment where, in fact, the Supreme Court has said that in view of alternate statutory remedy available by way of appeal before DRAT, the High Court ought not to have entertained the writ petition under Article 226, 227 of the Constitution of India, challenging the judgment and order passed by the DRT. By entertaining the writ petition straightway under Article 27 of the Constitution, permitted the borrower to circumvent the provisions of appeal before DRT under the provisions of the SARFAESI Act. in the present case, except the revenue records, the borrower did not file any evidence to show that the agricultural work was being done in the said property. Further, the secured creditor produced the photographs to show that there was no agricultural activities being done and no agricultural activity was going on. Therefore, the Supreme Court held that in case where the secured property is actually put to use as agricultural land and solely on the basis of the revenue records, pattadar, and once the secured property is put as a security by way of a mortgage, etc., meaning thereby the same was not treated as agricultural land, such properties cannot be said to be exempted from the provisions of SARFAESI Act under Section 31, subsection 1 of the SARFAESI Act. The Supreme Court further said, when no evidence was led at all on behalf of the borrowers that the secured properties in question were actually put to use as agricultural land and or any agricultural activity was going on, the High Court has committed an error in applying Section 31, subsection 1 of the SARFAESI Act and quashing and setting aside the entire possession notice, auction notice, as well as sale was bad in law. High Court has materially erred in shifting the burden upon the secured creditor to prove that the properties are non-agricultural land and have put to agricultural use. And finally, it was categorically held that in SARFAESI proceedings, the burden is upon the borrower to prove that the secured properties are agricultural lands and actually being used as agricultural land and or agricultural activities. So there are two things which are very important, which has been held by this judgment of Rao's construction. That one is that the High Court should be very, very careful in invoking Article 226 to 27 of the Constitution, giving relief to such parties where a separate remedy is available before DRAT. So in some cases, there may be a possibility that the DRAT is not functioning because of the judges are not there. But in all cases, the remedies are available in DRAT. So therefore, the High Courts should not entertain. So the most of the borrowers, they used to go to High Courts. The most of the borrowers, they used to go to DRAT. So DRAT also would take 50% of the total due amount before they can provide any relief or before they can even admit the appeal. Similarly, people were in fact trying to take time and trying to say that it is the time of the DM or CMM. They were taking a lot of time, but now that kind of time is also not being taken because there are many Supreme Court judgments in case somebody can go and ask anywhere if any kind of work is held up before any DM or before any CMM. I would say that the lenders can approach the Chief Secretary, lenders can approach the Chief Justice, lenders can also approach the Ministry for expediting this DM work, and lenders can also move to the High Courts that the DM is not taking timely action. So in further the judgment that I am going to discuss today, this also would be held that the DM has to do it within 30 days and maximum by 60 days. This order and the possession will be taken and handed over to the secured creditor. So this judgment is giving two reliefs to the lenders. One relief is that the Article 226 and 227 should be used very, very carefully when there is a remedy available before DRAT. So the application should not be admitted straightway. Secondly, for agriculture, whenever there is a claim from the borrower that the mortgaged property is an agriculture land, the burden of proof that it is an agriculture land, it is actually being used for agriculture purposes, is on the borrower and not on the lenders. Very clearly, this is actually creating a lot of comfort to the lenders for using SARFAESI law in the process of recovery of their dues. So the next issue is in the case of Siddha Neelkant Paper Industries Private Limited versus Prudent ARC Limited. This judgment also came on 5th January 2023. In fact, there are two judgments which came on 5th January 2023. This one is from Justice M.R. Shah and Justice K.T. Ravi Kumar. and this is on that amount of 50%, which is required to be submitted before any appeal is taken up by the appellate tribunal. And in this particular case, the borrower in fact argued that since some of the property has been sold, advance has been taken by the bank, so that amount should be considered as reduced from the 50% calculation, and also the interest which is not paid so far, that is also not to be added, and the 50% amount should be applicable on the principal amount as reduced by some amount which has been recovered by the bank on account of some advance taken on the sale of the same mortgaged property, which is now in question. So two issues: how the 50% has to be calculated, whether interest has to be added into that 50% unpaid interest. Secondly, in case there is any amount which has been recovered temporarily by the lenders, whether that also has to be reduced or not. So in this case, the definition of debt due was discussed under the SARFAESI Act, and finally it was held that the 50% amount would be calculated on the debt due, and the debt due includes interest. And the second question was that in case there is any advance received by the lenders, received by the secured creditor against the sale of the same mortgaged property, then whether that has to be reduced or not. So the Honorable Supreme Court said that in case this particular sale is accepted by the borrower, one side the borrower is challenging the sale of the property, and on the other side the borrower is saying that the money should be reduced from the total dues. In case the property has been sold, then of course the balance would be considered. So in this case, the debt due and all these definitions, these were the issues. Now in this case, the contentions were the debt means any liability inclusive of interest as per section 2 subsection HA of SARFAESI Act. The debt shall have the same meaning assigned to it clause G of section 2 of the Act, that the debt means any liability inclusive of interest, meaning debt due for the purpose of calculation of pre-deposit amount, whatever amount is mentioned in the notice under section 13(2) of the SARFAESI Act, in cases steps have been taken under section 13(2) or section 13(4) against the secured asset are under challenge before the DRT, will be the debt due. So that means whatever amount is mentioned in the notice under section 13(2) or in the notice under section 13(4), that would be the amount of debt due. 50% would be calculated on that amount. 50% would be calculated on that particular amount. And the next was in this case, the borrower said that the bank has also taken some advance on the sale of this property, and therefore that advance also should be reduced from the calculation of 50%. Now the contentions of the respondents and the contentions of the applicants further was like this: whether while calculating the amount of debt due, the amount deposited by the auction purchaser is required to be adjusted or appropriated towards the amount of pre-deposit to be deposited. Now, as per section 18 of the SARFAESI Act, it is the borrower who has preferred an appeal before the appellate tribunal, and the borrower who shall have to deposit 50% of the amount of the debt due from him. It is the borrower who has to deposit the 50% of the amount of the debt due from him. In other words, the borrower can take the benefit of the amount received by the creditor in an auction sale only if he unequivocally accepts the sale. Because in this case, he was even objecting the sale. He was challenging the sale. So this particular amount could not have been accepted as the amount appropriated towards the loan. Therefore, the 50% amount would be calculated on the amount of the debt along with the interest. Secondly, the amount which is mentioned in the notice under section 13 subsection 2 or section 13 subsection 4, that would be the amount which would be considered for calculating 50% along with the interest. So the amount which has been received, which has been recovered by the lenders on sale of a property which is not accepted, and that also part sale, and which is not appropriated to the account, also need not be reduced from calculation of 50%. So the decision will actually, I will read the decision, the held part. So in case where the borrower challenges the auction sale, thereafter it will not be open for the borrower to use the sale proceeds received from the sale of the secured properties to be adjusted, given credit in an application for waiver of pre-deposit. Pre-deposit contemplates under the second proviso of Section 18 of SARFAESI Act is mandatory in nature and cannot be waived by the learned appellate tribunal. In the present case, the respective high courts have seriously erred in directing to appropriate the amount realized by the auction sale of the secured properties deposited by the auction purchaser, while considering the 50% of the amount as pre-deposit to be deposited by the borrower, while preferring an appeal before DRAT. As per Section 2, subsection G, subclause G of the Act 1993, the debt means liability inclusive of interest as claimed by the bank, financial institution. So the decision of the Supreme Court further says the amount of debt due would include the interest as claimed by the secured creditor. Interest component shall be ignored only for the purposes of Section 18 of the Act. This judgment shall not affect the rights of the secured creditors to claim interest from the borrower for recovery of the amounts due under RDB Act. So the amount which is mentioned in the notice under Section 13(2), that would be the final amount on which 50% would be calculated. The any amount that has been repaid by the borrower or is recovered by the secured creditor after filing of the petition under Section 17 shall stand to the benefit of the borrower while computing the amount of debt due under the second proviso to Section 18 of the SARFAESI Act. The borrower has to deposit 50% of the amount of debt due as claimed by the bank, financial institution, assignee, along with the interest as claimed in the notice under Section 13(2) of the SARFAESI Act. And the borrower is not entitled to claim adjustment appropriation of an amount realized by selling the secured properties and deposited in by the auction purchaser when the auction sale is also under challenge. So in case we have to conclude, this is a very simple 50% has to be deposited. Then the calculation of 50% would include interest. 3, that the calculation of interest would not give any appropriation to any sale proceed which is not accepted. Any application of interest after the notice under Section 13(2) would not be considered. So 13(2) amount is final, 50% has to be paid by the appellant under Section 17. Going forward, the another judgment, which is Kotak Mahindra Bank Limited versus Girnar Corrugators Private Limited. Incidentally, this judgment is also dated 5th of January 2023, and this judgment has been given by Justice M.R. Shah and Justice Krishna Murari. So in case you would see, there are three judgments. There are three judgments on the same date, which is 5th of January 2023. So I would ask all the participants to, in case they can write their questions, answers, I would be able to take some question answers today, and we as we try, we would make it a little bit of kind of interactive webinars. Now, this Kotak Mahindra Bank versus Girnar Corrugators Private Limited. This was a case where the where this account was in default. Section 13, subsection 2 notice was given, and the application was filed with the district magistrate, and the for seeking assistance. And finally, in about 2 years, this is the more than a year was taken by the district magistrate, and finally the Naib Tahsildar. So finally, the Naib Tahsildar, in fact, refused to take possession of the property after the DM order, when the DM directed the SDM to take vacant possession of the secured asset. However, the Naib Tahsildar, who actually what finally authorized to take the possession, he refused to take the possession of the property for this particular loan, citing that there is a recovery certificate issued in favor of the respondent number 1, and there is another person respondent who somehow has filed a case before the Facilitation Council under MSME. The Facilitation Council, in fact, passed an order, and some lien was created on the assets of the company. So now, what is the situation? The situation is that this mortgaged property, first it was mortgaged to bank, Kotak Mahindra Bank, and the notice was issued. But then later on, it was seen that the Facilitation Council has passed an order for recovery of MSME dues under MSME Act, that the Tahsildar said that I cannot take over this property because there is a lien of MSME, and MSME Act, when it was read, and they were saying that the MSME Act has overriding clauses, and MSME Act is a later act, although the similar clauses are there in the SARFAESI Act, but MSME Act is a later act. So therefore, the MSME Act would prevail, and the first MSME debtor, MSME creditor would be settled, and then only the property can be taken over for the default of bank. So in this case, the High Court, in fact, set aside the order of the Naib Tahsildar, observing the presence of this SARFAESI Act would prevail. Then it went to the division bench, and the division bench of High Court held that in view of Section 24 of MSMED Act, which provides that the provisions of Section 15 to 23 of MSMED Act would have overriding effect and shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force, and in view of the fact that MSMED Act being a later enactment than SARFAESI Act, and the SARFAESI Act, the MSMED Act would prevail over SARFAESI Act. So this was the decision of double bench of the High Court. And then ultimately the bank had to prefer an appeal, so that the Kotak Mahindra Bank had to prefer an appeal before the Honorable Supreme Court, and whether the MSME Act would prevail over SARFAESI Act was the main issue to be decided. Now the conditions under the the appellant is the bank, and the appellant said that once we have Section 26E, which was inserted in SARFAESI Act in 2016, and it was provided in this Section 26 capital E that in case the security interest is registered with the central registry, which is SARFAESI, then the SARFAESI Act would prevail over all the recovery mechanisms, including MSME. However, it has been amended later that it is barring IBC, because in case the IBC will have overriding effect over SARFAESI. So, but then MSME, with the Section 15 to 23 of MSME Act only provides for special mechanism for adjudication of the dispute, along with enforcing certain other contractual and business terms on the parties, such as the time limit for payment and interest in case of delayed payment. The contentions also from the Kotak Mahindra Bank was that the entire MSMED Act, there is no specific express provision giving priority for payments under MSME Act, over the dues of the secured creditors or over any taxes or cesses payable to central government or state government or local authority, as the case may be. However, this kind of priority is mentioned in Section 26 capital E of SARFAESI Act. Therefore, such dues vis-a-vis the dues of MSME Act, as per the decree or the order passed by the Facilitation Center, that dues to secured creditors shall have a priority in view of Section 26 capital E of the SARFAESI Act, which is later enactment in point of time than MSME Act. Section 26E of SARFAESI Act is inserted in 2016, as I said earlier, is also having a non-obstante clause. As per settled position of law, if the legislature confers the later enactment with a non-obstante clause, it means the legislature wanted the subsequent later enactment to prevail. Thus, a priority conferred provided under 26E of the SARFAESI Act would prevail over the recovery mechanism of MSME Act, because the Section 26E was inserted after even the MSME Act. And it was also argued by the Kotak Mahindra Bank that MSME Act does not provide any priority over the debt due of the secured creditors as provided in Section 26E or in the IBC. The priority issue is not discussed. So, and then no jurisdiction under Section 14 of the SARFAESI to adjudicate the disputes between the secured creditor and the debtor. The DM has no jurisdiction, and the DM or even the CMM has no jurisdiction to adjudicate the dispute between the secured creditor and debtor. Under Section 14 of the SARFAESI Act, the DM or CMM is required to assist the secured creditors in getting the possession of the secured assets if any person is aggrieved by the steps under Section 30, subsection 4. So now finally, we have to see what is the decision of the Honorable Supreme Court. The Honorable Supreme Court has very clearly held that the orders passed by Naib Tahsildar refusing to take possession pursuant to an order passed by the DM under Section 14 of the SARFAESI Act was wholly without jurisdiction, and therefore, and the same was liable to be set aside. Further, it was clarified by the Supreme Court that the provisions of MSME Act, more particularly Section 15 to 23, no priority is provided with respect to dues under MSME Act like Section 26E of SARFAESI Act. So the court said that SARFAESI Act has a Section 26E which provides for the priority, whereas this MSME has got no priority as such, which is provided in the MSME Act. And the Section 26E was inserted wide amendment in 2016, provides that notwithstanding anything inconsistent therewith contained in any other law for the time being in force, after registration of security interest, the debts due to any secured creditor shall be paid in priority over all other dues, and all revenue, taxes, cesses, other rates payable to central government or state government or local authorities. So the secured creditor will have priority over all this. SARFAESI Act has been enacted providing specific mechanism provision for the financial asset and security interest. It is a special legislation for enforcement of security interest, which is created in favor of the secured creditor financial institution. Therefore, in the absence of any specific provision for priority of the dues under MSME Act, if the submission on behalf of the respondent number 1 for the dues under MSME Act would prevail over the SARFAESI Act, then in that case, not only the object and purpose of the special enactment, that is SARFAESI Act, would be frustrated. Even the later enactment by way of insertion of Section 26E of the SARFAESI Act would also be frustrated. Therefore, if the submission on the behalf of the respondent number 1 is accepted, then in that case, Section 26E of the SARFAESI Act would become nugatory and would become obvious and redundant. Any other contrary view would be defeating the provisions of Section 26E of the SARFAESI Act and also the objects and purpose of the SARFAESI Act. Therefore, it was held that the orders passed by the Division Bench of the High Court is unsustainable and deserves to be quashed and set aside. Recoveries under SARFAESI Act with respect to the secured assets would prevail over the recoveries under MSME Act to recover the amount under the award or decree passed by the Facilitation Council. If respondent number 1 is aggrieved by the order passed by DM under Section 14 of the SARFAESI Act, it will be open for him to initiate proceedings under Section 17 of the SARFAESI Act, which will be considered in accordance with law and on merits and subject to the provisions of Section 17 and provisions of the SARFAESI Act. The present appeal was therefore allowed. So the three things, Section 26 capital E is the overriding sanction on others because it came in 2016. In case we consider the orders passed by the Facilitation Council, then the SARFAESI law would become redundant because there may be, in most of the cases, some of the MSME dues are outstanding and anyone can go to Facilitation Center. So the Facilitation Council is not having an overriding powers. This is a very, very important judgment. So we have covered the SARFAESI. Agricultural land is sorted out. 50% has to be paid for filing an appeal. MSME is not something which is having a priority over the SARFAESI Act. So the Facilitation Council, if passes an order of decree or award, that cannot be considered as a lien on that property because the SARFAESI Act is having a overriding provisions under Section 26 capital E. Going forward, we have a judgment regarding the Bank of Rajasthan Limited versus VCK Shares and Stockbroking. This judgment was given in November 10th November 2022. So this judgment is regarding the, so I will just explain in very, very simple languages. And the simple language is that in this case, the Bank of Rajasthan filed an application for recovery of amount due from VCK shares before DRT. And the borrower entered appearance to defend the proceedings before the DRT. So the borrower was also a party, and the borrower also knew that there is a proceeding which is before the DRT, and the borrower did not say that it should be transferred or should not be transferred. So it was basically a division bench of the High Court held that a suit filed by a borrower against the bank was not barred before the civil court, although a suit filed by the bank against the borrower was barred. So in this case, the High Court, because the borrower also, in fact, another case was filed before the High Court, and the High Court somehow passed an order that the DRT suit should also be transferred to High Court, and the High Court would adjudicate. And finally, it was decided by the Honorable Supreme Court that there is no such power. There is no such power to transfer the case unless it is provided in the code. So the code doesn't provide, the Code of Civil Procedures does not provide that this can actually be transferred without the permission of the parties, or if anything is not even provided in the law. So this was also giving a little bit of comfort that the people who actually used to do multiple kind of shopping, one at DRT, one at High Court, and that is also restricted. The High Court has got no power to consolidate it at one place. So that is also kind of giving some relief to the SARFAESI actions. Now, the other important judgment is Balkrishna Rama Tarle, who in fact was deceased through their legal representatives, versus Phoenix ARC Private Limited, and this judgment was dated 26th of September. It was given by, again, this same judge, Justice M.R. Shah and Justice Krishna Murari. So this was a case where the loan Religare, in fact, Religare Finvest sanctioned a loan of 6 crores in favor of the borrower, and it was secured by a registered mortgage created by the borrowers in favor of the Religare. The borrower committed default and the account became NPA. Religare issued notice under Section 13(2) of the SARFAESI Act, called upon the borrowers to pay the amount, and assigned a deed of assignment. Religare assigned all its rights. Everything was original petitioner before the High Court. Thus, the first respondent, like the Phoenix came as in place of Religare. The secured creditor took symbolic possession of this property. Now, in this case, when this case was filed before the district magistrate, requesting for taking over the physical vacant possession of the secured asset, the district magistrate, in fact, declined to assist because there was a tenancy on the property, and the tenancy was created before the mortgage. The tenant appeared before DM. And DM said, "My tenancy is valid, and I'm a bona fide occupier of this property, and this kind of order cannot be passed, and I cannot be evicted from the property." In fact, the DM declined to pass an order and provide the help and refused to take physical vacant possession of the property. Then in that case, the secured creditor, which is now it's like the Phoenix ARC Private Limited, and in this case, the secured creditors finally decided to file a petition before High Court, and the High Court said being dissatisfied with the High Court, whereby the ADM was directed to dispose of the application. The ADM or the DM was directed to dispose of the application, and being dissatisfied with the impugned judgment of the High Court, the third party petitioner, claiming to be a tenant in some of the secured assets, preferred the appeal. So this appeal was filed by the tenant. It was a special leave petition before Honorable Supreme Court against the judgment of a High Court, and the High Court, in fact, directed the DM to dispose of the application under Section 14. Do not consider the tenancy. The tenancy would be considered by the DRT and not by the DM, because the DM is not supposed to adjudicate some of the disputes between the lender and the borrower. The DM is also not supposed to take up the jurisdiction which is specifically provided to DRT in the case of tenancy. So in case we go forward, then the basically issue which was supposed to be decided, whether during exercise powers under Section 14 of the SARFAESI Act, the district magistrate or the designated authority can pass such orders that unless and until the secured creditors terminates the tenancy rights of the third person by following due procedure of the law and further orders regarding possession of the mortgage property only, then an application under Section 14 of the SARFAESI Act will be decided. The contentions which was given by the petitioners, the High Court ought to have appreciated that the tenancy was subsisting and continuing since prior to the mortgage of the property, and therefore their rights are to be protected, and unless and until the proceedings are initiated for eviction of the tenant, the secured creditor who will be in the shoes of the original landlord cannot get the possession in an application under Section 14 of the SARFAESI Act. So they cannot get the possession because the possession is with the tenant. Now, the decision of the Supreme Court says very clearly that the CMM-DM is immediately to immediately move into action after the receipt of the application. So this judgment, in fact, we can actually say that this judgment is very, very important for most of the DM cases. So Balkrishna Rama Tadle versus Phoenix ARC. So in this case, as soon as application under Section 14 is received, basically the duties of the CMM-DM was clarified, was mentioned in this order, and the Supreme Court says that the CM/DM is immediately supposed to move into the action after receipt of a written application under Section 14(1) of the SARFAESI Act from the secured creditor for that purpose. Secondly, as soon as the application under Section 14 is received, the CM/DM is expected to pass an order after verification of compliances of all formalities by the secured creditor referred to in the proviso in Section 14(1) of the SARFAESI Act, and after being satisfied in that regard, to take possession of the secured assets and documents relating thereto, and to forward the same to the secured creditor at the earliest opportunity. Once all the requirements under Section 14 of the SARFAESI Act are complied with, satisfied by the secured creditor, it is the duty upon CM/DM to assist the secured creditor in obtaining the possession as well as documents related to the secured assets, even with the help of any officer subordinate to him or with the help of an advocate appointed as advocate commissioners. Under these circumstances, the present case, no error has been committed by the High Court in setting aside the order dated 27th of August 21, passed by the designated authority, keeping the application pending till secured creditor initiates the legal proceedings for eviction of the tenant cannot get possession. So in case we see, the Supreme Court has said that the CM/DM has no power to adjudicate the tenancy issues or any kind of dispute between the debtor and the creditor. Number two, the CM or DM has to move into action immediately on an application submitted in writing. Then the says that it has to take possession of the secured asset along with the documents and hand it over to the secured creditor. He can also appoint an advocate commissioner, or he can also appoint any officer subordinate to the CM/DM. So there is no such kind of order can be passed by the CM/DM that first of all you evict the tenant after initiating the legal proceedings. Then only that kind of order can be passed, or then only the assistance can be provided. So as far as tenancy is concerned, I would actually say that the section tenancy of in case we see the tenancy is also a kind of issue which has been dealt with in Section 18. I will just read for the SARFAESI law in Section 18. You would see so in fact, this is Section 14 that I am trying to show it to you. Section 14 of the SARFAESI Act. So in this Section 17, subsection 4 capital A was inserted. Subsection 4 capital A was inserted, and in that section it was very clearly said, this is Section 4A, where any person in an application under subsection 1 claims any tenancy or leasehold rights upon the secured asset, the Debt Recovery Tribunal, after examining the facts of the case and evidence produced by the parties in relation to such claims, shall, for the purpose of enforcement of security interest, have the jurisdiction to examine whether the lease or tenancy. So this jurisdiction has been shifted to DRT. So whenever there is any kind of tenancy which is claimed, the tenant can file an appeal before the DRT, can file an application before the DRT, and the DRT can decide whether the tenancy has expired or stood determined, or in contrary to Section 65 capital A of the Transfer of Properties Act, or in contrary to terms of mortgage, is created after the issuance of notice of default and demand by the bank under section 2 or 13, the debt recovery tribunal is satisfied that the tenancy rights or the leasehold rights claimed in secured assets fall under subsection A or subsection B or subsection C or D of clause I, then notwithstanding anything to the contrary contained in any other law for the time being in force, the debt recovery tribunal may pass such order as it deems fit in accordance with the provisions of this act. So this particular amendment was in fact made in the law with effect from 1st of September 2016. 1st of September 2016. So the law in fact was made that this tenancy issues can also be tenancy issues will be within the jurisdiction of DRT. So we have reached this part, and there are further judgments on Supreme Court and further on the High Courts that we will take up in part 2. And we will take up now the questions, because I have seen there are a lot of questions which has actually been raised. So if I just see the questions, let me see the questions first, starting from the first questions. Sir, what shall be the date of debt in this case, date of NPA? I think I'm not sure which case you're talking about. Mr. Ankur Bansal is asking this question. Then the Satish Kumar Patnaik is asking a question, sir, whether the secured creditor is entitled to appropriate the deposit amount made by the appellant under section 18 after the appeal is dismissed by DRAT on merit. If the appeal is allowed, then what would be the fate of the amount so deposited? So the appellate tribunal will also pass an order, whatever amount has been deposited by the appellant, what will happen to that particular amount in case the appeal is lost, or in case his appeal is won, and to what extent the appeal has been won. The appellate tribunal will also direct how to appropriate this amount, because this amount as pre-deposit is not deposited with the bank, it is to be given to the appellate authority's office. So the DRAT will decide. AJ Vaidyanathan is asking whether going concern concept applicable in SARFAESI Act, and if a particular security invoked in SARFAESI chokes the production of the company. Now, see, there is a concept of taking over the management by the secured creditors, but that particular concept has not really been activated because some of the rules are still awaited, and the government now is probably not interested that under SARFAESI, the banks can take over the businesses of the companies, businesses of the borrowers, and run it for some time. So that is not readily usable provisions, because some of the rules are still made. Even if the production is continuing, and if the SARFAESI action is invoked, the DM has got no authority to say that the production is going on, and I will not give the permission. The police help will be provided. The physical possession will be taken for the factory price, and then can it be sold. So there is no concept that if the company is a going concern, then the SARFAESI Act is not applicable. That is not the law so far. Mr. Amit then is asking, I represent Girnar Corrugated Private Limited Indore. Now, how can we execute decree order passed by MSME Facilitation Council? So the decree order can be routed through a court where these decree orders are implemented, executed. The execution of decree would be done on other properties. And the only order which has been passed in this case is that the order, it says that the SARFAESI, like section 26 capital E of the SARFAESI Act, does not allow any other person to come in and have a lien on the property, because that property is already mortgaged. But in case MSME Facilitation Council has passed an order, and has issued a recovery certificate. So the execution of the recovery certificate can be possible through other court. And that court would be like a civil court, where the civil court will find out the inventory of the other properties, and the civil court will pass an order of attachment of those properties first, and then the attached properties can be sold and the money can be given to the MSME creditor based on the order passed by Facilitation Council. Mr. Amit Jain further says that how a MSME unit can recover his dues from a buyer who has become bankrupt and his all assets are with the banks. Yes, in case of a buyer, in case of a company, in case of a buyer who has become totally bankrupt, I don't think then the MSME supplier would be a operational creditor under insolvency law. Under SARFAESI law, the borrowers would actually have a right over the properties. And in case there is no asset available, then the recovery for MSME creditor would not be possible. However, my argument always have been that as far as these MSME suppliers are concerned, their risk is restricted to one supply cycle. In case they are supplying goods to a particular customer and who is not making payment for at least one supply or basically two supplies, then the MSME supplier should not continue to supply and should restrict their exposure to only one supply cycle or maximum two supply cycles. And then the recovery process should be started. And if it is more than 1 crore, then the insolvency application is the easiest nowadays. And there is no way that a person is not giving you payment and MSME supplier is continuously supplying to that particular buyer for years and investing and risking his money. I'm only saying that the MSME supplier should restrict their risk to maximum 1 or 2 supply cycles. There is another question which is coming from a person who doesn't want to disclose his name. Sir, I have leave this call due to some engagement. See, Mr. Ajay Shukla. The other question is from Arun Kumar Srivastava, and he says if the property is not registered with SARFAESI within timelines, but charges are registered under the Companies Act, whether the registration under SARFAESI Act can be made or lender should approach DRT under RDB Act. So I believe there are provisions so that you can register yourself before the SARFAESI. Even delayed registration is also possible. In case the charge is also created on Companies Act, the SARFAESI registration would also be done. Even if it is delayed, I think there is a process that you can still go to SARFAESI and register. And then you can take action under SARFAESI or under insolvency, both ways. Or in case you find that it is not really possible, then we can actually file an application under the RDB Act before the DRT. So that's what is for today, and we will come out with part 2, where some of the remaining judgments on SARFAESI and RDB Act from Supreme Court, and also the landmark judgments from various high courts also would be presented in the next episode, which will be 45th episode on Saturday, 11 a.m. We are also preparing a very, very detailed webinar on the obligation to pay Provident Fund and the gratuity because of the judgment of Jet Airways from Supreme Court and various other judgments from NCLAT. That also would be a very, very interesting, webinar. And after this part 2, we would be doing that. So this is all for today. Thank you very much, participants. And we, in fact, become very happy when the participation increases. This particular recording also would be uploaded on the YouTube channel of AAA Insolvency, and please subscribe to the channel so that the intimation comes to you. Thank you very much. It's a pleasure always to be connected with all of you. Thank you.